What happens when someone walks into a courtroom and truly believes the law doesn't apply to them? As in today's jaw-dropping courtroom drama, we witness two separate cases where defendants attempt to challenge the entire legal system using so-called sovereign citizen arguments, and the results are absolutely intense. In the first case, a man facing serious felony charges for resisting and obstructing a police officer insists on representing himself. Despite having limited education and no formal legal training, he confidently rejects professional attorneys, calls them corrupt, and refuses to follow standard court procedures. The judge patiently explains the risks of self-representation, warning him about the consequences of interrupting the court and failing to file proper motions, witness lists, and jury instructions. But instead of backing down, he doubles down, creating a tense back and forth that shows just how risky it can be to take on the legal system alone. Then, in a completely different case, a woman involved in a landlord-tenant dispute claims she has rescinded her contract under common law and insists she is not a legal person. She challenges the court's jurisdiction and even argues that reasonable doubt applies to a civil case. The judge firmly clarifies the law, dismissing these claims while maintaining control of the courtroom as interruptions escalate. The situation becomes even more emotional as the broader consequences of these beliefs start to surface. This video highlights real courtroom moments that are shocking, educational, and at times frustrating to watch. It's a powerful reminder that understanding the law, and respecting courtroom procedure, can make all the difference when your future is on the line. Watch till the end because each moment gets more intense than the last.
FH. This is a date and time set for a final pretrial conference. Today was the motion deadline for both motions and motion in limines to be heard. Jury instructions were to be provided to the court by April 2nd, along with any proposed voir dire questions. We are set for trial on April 22nd of 2025. Mr. Raymer, you are charged with police officer resisting and obstructing causing injury, which carries a maximum penalty of up to 4 years in prison. Police officer assaulting, resisting, and obstructing, that carries up to 2 years in prison. There's two of those. And then there's a disorderly. And what is the plea offer in this file?
Your Honor, the people have offered to a plea of 2 counts to attempted R&O.
All right.
So 2 misdemeanors, and we would kill a brute to no upfront jail.
All right. Mr. Raymer, the plea offer in this case was to plead to 2 one-year misdemeanors with no upfront jail, and there'd be like 12 months or so of probation and some minimal fines and costs. Do you understand that? All right. Now, Mr. Raymer, I'm assuming you graduated from high school, right?
8th grade.
You went through 8th grade. And this is a felony that could result in you going to prison. Why don't you stand in front of that podium for me? So do you understand an attorney can help guide you through the legal process?
Yes, I tried to have, I almost had a public defender. Unfortunately, she wasn't representing me appropriately. I'd asked for another one, but.
So I have no authority over who gets appointed. You're appointed an attorney.
I understand that, but when they're not representing you appropriately.
Okay, I didn't ask that. I'm just saying. You have a right to an attorney. I know the attorney you're referring to. She's diligent. She works hard. Maybe you didn't like, I know when I was a public defender, sometimes my clients didn't like listen to me, I'm talking. My clients didn't like the things that I told them, but her job isn't to do what you want. Her job is to represent the law. So you understand at this point, you can hire an attorney, or you can go with the public defender and whoever they assign you, or you can go to trial pro per with no law degree, no experience, and risk going to prison. You're going to represent yourself.
I'm going to represent I ain't got no choice but to represent.
Have you provided your jury question, the voir dire questions? Because if you haven't, they're waived.
If there's no,
they were due.
If there's evidence provided against me, I have a right to defend myself using that very same.
That wasn't the question I asked you.
You
do have a right to defend yourself, Mr. Raymer. I'm just.
My right for violence.
I'm talking. You are not. If you don't stop talking and listen to me, so I can go through my speech, I will send you over to the jail. Do you understand? All right. You have not filed any motions. Jury instructions were due and voir dire questions were due. You have not provided those. We gave you a copy of this. So do you understand what I've received is what will be used? Yes or no?
I will be allowed to ask my questions.
What question?
When I'm cross-examining, I will get my.
I'm talking about juror question. I'm talking about jury instructions and voir dire questions. You understand now? You didn't follow, listen, I know, but you waived that because you have not provided them. Do you understand that? Do you understand that?
No, I don't. I don't
Okay.
understand that. I didn't understand that.
Okay. Well, I
That's why
can't advise you of the law because I'm not an attorney, I'm a judge.
No, but you're looking at the case and you've been presiding over my case for 3 years now.
I know. It's fine. You're going to go to
You're the
trial.
one that signed the warrant for my arrest while I was in jail.
I don't know that. I don't remember.
Yes, you did do that.
Okay. I'm allowed to do that.
No, you violated my rights.
Okay. Well, you have options. You can file a complaint with the JTC if you'd like. So are you prepared to go to trial?
Absolutely.
Have you provided your witness list?
I haven't yet, but I will.
Okay, that was due.
My witness list was provided when Ms. Underwood was my attorney.
Okay.
And my witness list is.
Have you subpoenaed any witnesses that were not on the prosecutor's raised just eyewitness list?
Yes, my witnesses are the ones that was there at the scene.
No.
And, yes.
Do you understand that you have to provide a witness list and you have to provide a copy to the prosecutor? Do you understand that?
Prosecutor, I gotta provide what to him?
So if you're going to have witnesses at trial, you need to make sure the prosecutor has their name and contact information so that they could interview them prior to trial if they wanted. Do you understand that?
Well, they got all that information.
They do?
Yes.
Okay.
Yes.
So
my witnesses are my parents and my aunt.
okay, I don't know. Are those on, if they're not on the people's witness? Okay, if you haven't provided a witness list and they're not on the people's list, you understand you won't be able to call them.
Okay, I will provide the information.
Okay.
I will provide that information.
I'm just telling you. So you need to make sure that there's a witness list in the file that was provided to the people.
So I gotta re-provide it.
I don't know. Go back and look at what witness list has been
do that
filed, their name, their contact information, and then any subpoenas you have to do. If you have to subpoena anybody to be present, you need to get those filed this week. And then the court signs them and then you serve those people with those.
Okay.
Do you understand? Now, do you understand when we go to trial, a lot of times some of the questions you ask or he asks may be objected to, and it's not personal. It's just, you know, we have to follow the law.
Yeah.
Okay.
I'm allowed to object to though, right?
Huh?
I'm allowed to object to.
You are, and then you have to provide the basis for that objection.
Yeah.
Okay, so you need to understand your objections. So you might want to do some research to understand.
I've been doing.
Good. You sure you don't want a public defender for trial?
Huh?
You sure you don't want an attorney for trial?
I'm not gonna take any of the attorneys from here because they're all corrupt.
Call the case of the Ranches of Rosebrook versus A Nice Battle, case number 25C-1245.
Good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Ms. Battle, please hit *6. Unmute your device. And state.
Hello? Hello?
Please state.
It's Denise Battle on a special appearance for the record to contest the jurisdiction and the facts before this court.
Yep. All right. Well, Ms. Battle, I'll tell you that this matter is appropriately in the correct court. The court does have jurisdiction.
And that's based on what? What is on the record that is based on that the court has jurisdiction?
The fact that this is a case that is within the jurisdiction of the Township of Ypsilanti, and if you have issues related to any contracts, that would be within this jurisdiction as well. So all of that is within the jurisdiction of this court.
So you're saying that the contract is in jurisdiction of the court?
That is what I just said, ma'am.
All right, and the contract has been rescinded. So how is the contract in the jurisdiction of the court if it's invalid?
Who gets to rescind a contract on their own? That's
what are you talking about? I have the right to rescind a contract by right of common law.
Ms. Battle,
That doesn't involve court.
Ma'am, you need to stop talking or you're going to get held in contempt of court. Mr. Fantier, have you had a chance to talk to Ms. Battle? I talked to Ms.
You're breaking up. I can't hear you.
Mr. Fantera, do you need to speak with her or are we ready to speak?
If you want me to speak to her, I'll speak to her. You know, I mean, she talks about rescinding the contract. Does that mean she's moving out?
I'm sorry, you're breaking up.
Are you moving out?
Are you moving out?
No. Why would I have to move out?
Because if you rescind a contract, okay, fine. Your Honor, I think let's set this for trial.
Okay. One moment.
This case has also been in the, it's in the circuit court. A petition filed for an injunction. I did serve you all. It is set on the 30th.
Yes, ma'am, I heard.
We're aware.
Okay. And once again, I do not submit to the jurisdiction of the court. The contract is rescinded.
So how can the
And I am
contract,
not a legal person.
you're not a legal
How
person?
can a contract, legal person? I'm not a legal entity. No, I am not. And you have to prove that on the record.
Stop talking.
Actually, I don't.
I'm sorry.
Can I ask Ms. Battle a question, Your Honor, real quick?
Sure.
So, Ms. Battle, so you can live there forever without paying rent because you're not a legal person?
That's not what I'm saying, but the contract itself is invalid. I'm saying that you don't have any personal or subject matter jurisdiction over me. Over an invalid contract, no. And over me not having a legal capacity to be sued, yes. So if that's how you want to take it, then that's how you have to take it. But that's what's lawful, and that's what's written in the law.
Let me just tell you, I think you're wrong on both counts. I would expect that we would.
It's okay for you to think that I'm wrong, but the facts still align with what I'm saying.
Okay, Your Honor, I think we should have a trial.
You have to prove without the reasonable doubt. So let the record show that the judge has not required the plaintiff to prove without a reasonable doubt that I am a legal person, and it's on the record, not assumed, not presumed, on the record. There's nothing that's on the record that states.
Ms. Battle, first of all, reasonable doubt is a standard in a criminal case, not a civil case. So I do not have to prove anything beyond a reasonable doubt.
I need both of you to stop talking, please. Both of you, I'm sorry. I cannot figure out the date because I can't hear over the two of you.
I apologize. I didn't know that's what you were doing, Your Honor.
This matter will be scheduled for May 6th at 3 p.m. for a trial on any and all issues that may be before the court. Ms. Battle, if you have anything else that you need to say, you can unmute yourself by hitting *6 to do that.
Okay, I just find it ironic that I got muted when I was speaking on jurisdiction and how there was a lack thereof on the record. So I want that to be on the record. But I also wanted to, okay, that's fine. And I also wanted to be on the record that I am not going to be able to show up on May the 6th. So it's also ironic that you are able to verify with him that he's able to show up, but not with myself.
I just asked you that, and you are now talking about something else. Why can't you do this?
That's because you cut me off and put me inside of a break room and muted my mic instead of allowing me to speak on what needs to be spoken on.
What happens when someone walks into a courtroom and genuinely believes the law has no authority over them? Not just that the charges are unfair, but that the entire system itself doesn't apply. That's exactly what unfolds in these two intense hearings, where confidence collides head-on with courtroom reality. The first case centers on a man charged with resisting and obstructing a police officer, a felony offense carrying the possibility of years behind bars. From the very beginning, the tension is obvious. Instead of accepting a court-appointed attorney or even considering professional legal guidance, he insists on representing himself. He makes it clear that he does not trust lawyers. He calls them corrupt. He believes he understands the law well enough to defend himself. The judge, calm but serious, immediately begins explaining the risks. She tells him that representing yourself in a felony case is dangerous. The law is complex. Procedures matter. Deadlines matter. Paperwork matters. One missed filing or one misunderstanding could change everything. She reminds him that the prosecution is trained. They know the rules. They know how to present evidence properly. She warns him that if he chooses to represent himself, he will be held to the same standard as a licensed attorney. But he interrupts. Over and over again, he cuts her off, insisting he understands. He claims the court has no real authority over him. He dismisses the need for formal motions. He brushes aside the idea that he must submit jury instructions or file a proper witness list. He believes that if his parents or his aunt want to testify, they can simply show up and speak. He doesn't seem to realize that courtrooms don't operate on assumptions, they operate on strict procedural rules. The judge explains that she cannot guide him step by step. She cannot give him legal advice. She cannot tell him how to build his defense. Her role is to ensure the process is fair, not to act as his personal legal coach. Every time she tries to explain this, he interrupts again, questioning the legitimacy of the system itself. There's a plea offer on the table. The prosecution is willing to reduce the charges to misdemeanors, offer probation, and avoid upfront jail time. It's a significant reduction considering the seriousness of the felony. The judge makes sure he understands what's being offered. She makes sure he knows the maximum penalty if he goes to trial and loses. Still, he resists. He seems convinced that if he simply challenges jurisdiction strongly enough, the case will collapse. But the courtroom doesn't respond to belief, it responds to law. And as the hearing continues, the gap between his confidence and the legal reality becomes wider and wider. The judge grows firmer. She warns him about interrupting. She tells him that courtroom decorum is not optional. Respect for the process is mandatory. Even if he disagrees with the law, he must follow the rules while he's inside that courtroom. At several points, you can feel the frustration in the room. Not explosive frustration, but the kind that builds quietly when someone refuses to hear what is being carefully explained. The judge's tone remains measured, but the seriousness of the situation becomes impossible to ignore. She makes it clear, if he proceeds without counsel, the consequences will be his responsibility. It's a powerful reminder of something many people underestimate: the legal system is procedural. It's structured. It's not about who speaks the loudest or who feels the most confident. It's about filings, evidence, admissibility, timelines, and statutes. Then the video shifts to a completely different case, but with a surprisingly similar theme. This time, it's a landlord-tenant dispute. A woman has stopped paying rent. Instead of arguing about habitability issues or payment disputes in a conventional way, she claims she has rescinded the contract under common law. She argues that she is not a legal person. She challenges the court's jurisdiction over her entirely. The judge immediately addresses the jurisdiction question. The court has authority. The contract exists. The dispute falls squarely within civil law. But the defendant insists that by declaring herself outside the system, she is no longer bound by it. The judge calmly explains that contracts cannot simply be erased by unilateral declaration. Signing a lease creates obligations. Living in the property while refusing to pay rent creates consequences. Civil court operates under a preponderance of the evidence standard, not beyond a reasonable doubt. But she repeatedly references reasonable doubt, showing a fundamental misunderstanding of the difference between criminal and civil law. Interruptions begin again. The judge attempts to speak. The defendant talks over her. The court tries to clarify procedure. She circles back to jurisdiction. Eventually, the interruptions escalate to the point where the judge has to mute her temporarily to maintain order. There's another layer to this case that makes it heavier. Her children are present during the proceedings. You can sense the broader implications. This isn't just about unpaid rent anymore. It's about belief systems, about how misinformation spreads, about how legal misunderstandings can ripple into family life. The judge schedules a trial date. The defendant claims she cannot attend. The court explains that scheduled hearings are not optional. Civil procedure has timelines. Deadlines must be met. Ignoring them doesn't invalidate them. As the exchange continues, the contrast becomes striking. On one side, you have individuals who strongly believe in a particular interpretation of law, often rooted in online communities or misunderstood legal terminology. On the other side, you have judges grounded in statutes, precedent, and procedural codes. What stands out in both cases is not anger, it's patience. The judges do not mock. They do not yell. They explain. They warn. They clarify. But they also draw clear boundaries. Courtrooms are not debate clubs about whether law exists. They are institutions that function on established authority. There's a lesson woven through both hearings. Confidence is not competence. Declaring independence from the legal system does not remove its power. Refusing to participate in procedure does not stop the procedure from moving forward. In the first case, the risk is prison time. In the second, it's eviction and civil judgment. The stakes are different, but the pattern is similar: misunderstanding the law while underestimating its consequences. Watching these moments unfold is intense. You see people who truly believe they are standing on principle. You see judges trying to prevent self-inflicted damage. And you see how quickly courtroom patience can turn into firm enforcement of rules. By the end of these hearings, one thing becomes undeniable: the legal system does not disappear simply because someone rejects it. It continues. It schedules. It rules. It enforces. And perhaps the most powerful takeaway is this: understanding your rights is important, but understanding your responsibilities is just as critical. Courtrooms are structured environments built on procedure. Walking into them without preparation, without knowledge, and without respect for that structure can lead to outcomes far more serious than many people expect. These cases aren't just dramatic, they're cautionary. They show what happens when belief meets reality, and when courtroom authority is tested by unconventional arguments. In both hearings, the law remains steady, even as emotions and interruptions rise around it. And that steady, procedural force is something no declaration can simply undo.